Hi, my name is John Kelly. I'm doing a video series on adult care in facilities such as assisted living and nursing homes, vulnerable adults. And this is going to be chapter 2 of this 7-part series. So I hope that I can cover some topics that are helpful to you. This chapter is understanding the care settings. So we're going to talk about assisted living versus nursing home versus group home versus memory care. If you're watching this, it's likely that you're trying to make sense of a system that feels confusing on purpose. In this chapter, we'll talk about what these care facilities actually are, how they differ, and why the setting matters medically and legally. I'm here to help you understand and navigate what can feel overwhelming. In the last chapter, we talked about the common pathways of harm: neglect, falls, medication errors, infections, pressure injuries, violence, and wandering. Now let's pause and understand the playing field. Because when you know what kind of facility you're dealing with, you can ask better questions and recognize red flags faster. A vulnerable adult is not just someone who is older. It can be an elder. It can be a person with disabilities. It can be someone with a brain injury, a developmental disorder, serious mental illness, or memory loss. The common thread is not age, it's dependence. So a vulnerable adult depends on others for safety, care, supervision, or decision-making. And when dependence increases, the standard of care rises within it. Now, the 4 major settings families run into are assisted living, nursing homes, skilled nursing facilities, group homes, and memory care. These labels sound clean. Real life is typically not. Let's talk through each one. First, assisted living. Assisted living is often marketed as help with daily living rather than medical care. Families hear things like meals, housekeeping, medication reminders, bathing assistance, social activities. It often looks like apartments with dining hall and calendar full of events. It can be a good setting for the right resident. But here's the uncomfortable truth. Assisted living has increasingly become a place where people with high medical needs live because families need somewhere to put them. Hospitals need somewhere to discharge them, and facilities know how to sell hope. The assisted living staff may include caregivers and med techs. Some have nurses on staff, some have limited nursing presence. The depth of the medical oversight can vary wildly. So in assisted living cases, the core legal question is often, what did the facility agree to do? What did the resident actually need? And did the facility accept the resident anyway? Because duty follows acceptance. If you accept a resident with a known fall risk, known incontinence, known swallowing risk, known skin breakdown risk, or cognitive impairment, you don't get to act surprised when the harm occurs. Nursing homes and skilled nursing facilities, sometimes called SNFs, this is higher acuity. More residents are medically complex, bedbound, or recovering from hospitalizations. There is supposed to be more clinical monitoring and more nursing responsibilities. And you'll see things like care plans, treatment records, wound documentation, assessments, and physician involvement. In nursing home and SNF cases, there are often more records, more measurable obligations, and therefore more ways to prove what should have happened and what didn't. But here's the paradox. More regulations doesn't automatically mean better care. Sometimes it means better paperwork. And sometimes paperwork becomes a camouflage. Now I'll talk about group homes. Group homes vary more than almost any other setting. Some are loving and stable, well run. Some are understaffed and undertrained and designed to run on the cheapest labor possible. So group homes often serve adults with developmental disabilities, traumatic brain injuries, serious mental illnesses, mobility impairments, seizure disorders, or complex behavioral needs. Group homes can be small, 4 residents, 6 residents, 8 residents, and they can feel more like home-like, which families like, but small can also mean isolated, and isolation is where abuse hides. In a group home, supervision is often the linchpin. If a resident needs constant line of sight supervision and the home has 1 staff for 6 residents, the math just doesn't work. If a resident has a known choking risk and meals are rushed, harm is predictable. If a resident has behavioral outbursts and the staff isn't trained, restraint and injury become the default response. Now we'll talk about memory care. Memory care is not just assisted living with locked doors. It's its own standard of care. Memory care residents are often living with dementia or other cognitive disease. That means impaired judgment, wandering risk, or increased fall risk, and difficulty communicating pain, and sometimes aggression or fear-based reactions. Memory care should mean trained staff, environmental safeguards, consistent routines, protection from elopement, protection from resident-on-resident harm, and a care plan that anticipates predictable dementia behaviors. When a memory care fails, it often fails in 2 ways. The environment isn't safe, and the human response isn't skilled. Now let's talk about the most important concept across all settings. Marketing doesn't define duty. The resident needs to define duty. Facilities often try to hide behind labels. We're not a nursing home. We don't provide medical care. We're just assisted living, or some of the things you might hear. But if they accept someone who cannot safely toilet alone, cannot safely ambulate alone, cannot manage medication, cannot swallow safely, cannot protect their own skin, or cannot stay inside without wandering, then they have accepted a duty to manage those risks. This matters for families because you can trust your instincts when you see mismatch. If a facility looks like a hotel, but your loved one needs hospital-level attention, that mismatch is a danger. It matters for your family because it becomes your theme. They took the money, they took the resident, they took the duty, they tried to disclaim it after harm occurred. Now let's briefly talk about how care is supposed to be organized. Care plans, service plans, and the reality gap. Most care plans are supposed to have some version of a plan. In assisted living, you'll often see a service plan. What assistance will be provided? In a skilled nursing, you'll often see a formal care plan and assessments. In group homes, you may see an individualized plan or behavioral plan. Sometimes these are tied to disability services. The plan is supposed to answer what risks exist, what interventions are required, who is responsible, and how often must care occur. It's also assessing how will changes be identified. But here's what happens in bad facilities. Plans are written to satisfy admissions, regulators, and families. And then the floor runs on crisis. Call lights go unanswered. Turning schedules skipped. Waits are missed. Wound checks delayed. Toileting plans ignored. Aggressive residents not separated. Medications not reconciled. Hospital discharge instructions filed away like a junk mail. The plan becomes a piece of paper that everyone points to, but nobody lives up to it. If you're a family working with an attorney, this is where you build your evidence. You show the plan, you show the staffing, you show the charting, show the gap, because the gap is negligence. Now a word about corporate structure. In modern elder abuse and vulnerable adult cases, the facility is often not one entity. There may be an owner, a managing company, a license holder, a real estate entity, and outside staffing agencies. It can look like a corporate shell game. So why does this matter? Because the responsibility often sits at the level where the staffing is decided. And staffing is often a business decision, not a clinical one, which brings us to the theme you'll hear me repeat. Understaffing is not an accident, it's often a business model. Now, before we move on, I want to give you a quick checklist, family-facing, plain-spoken, of questions that cut through the fog. If you're touring or you're already worried, ask, who is the nurse on duty and when? Is the nurse on site overnight? What is your staffing ratio on days, evenings, and nights? How do you handle toileting assistance? How quickly are your call lights answered? How do you prevent falls or high-risk residents? How do you prevent and treat pressure injuries? Who does the skin checks? How do you handle residents who wander? What alarms and checks exist? If my loved one reports pain or change in condition, who evaluates and how fast? How do you prevent resident-on-resident violence? If there's any incident, how and when will the family be notified? Do you have cameras? If so, where? How long is the footage kept? A good facility answers directly. A bad facility answers with smiles and vagueness. Now that we understand the settings, we can talk about the injuries and red flags, the medical realities that show up when a care is missing. In the next chapter, we'll talk about the specific injuries and harm patterns common in these cases. That is, pressure sores, their stages, malnutrition and dehydration, fractures, aspiration, pneumonia, UTI to sepsis pathways, medication errors, assault, and the ways wrongful death often unfolds in facility neglect cases. We'll also talk about what these injuries mean, not just medically, but legally, because in many cases, the body becomes the witness when the vulnerable adult cannot speak. Now that I've gone over the types of facilities, if this brings up questions that you have regarding one of your loved ones or someone that you know that you think may be at risk as a vulnerable adult, please feel free to reach out to us at Kelly Law Team. Our number is 602-283-4122.